I'm going to refer to the concept of legal order in Alchurron's and Boulighin's theory. First, legal system and legal order. In Logical Foundations of Probability, Rudolf Carnap explains the significance for scientific activity of the conceptual explication, meaning by it the transformation of an inexact pre-scientific concept, the explicandum, into an exact one, the explicatum. He maintains that this is a necessary activity for the clear formulation of a problem, and points out that an adequate explication must meet the following conditions. First, the explicatum must resemble the explicandum in a way that, in most cases in which the explicandum has been used before, the explicatum can be employed. Second, the characterization of the explicatum, that is to say, the rules for its use, must be given in an exact way, so as to bring the explicatum into a well-linked system of scientific concepts. Third, the explicatum must be a fertile concept, that is, useful in the formulation of many universal statements. And fourth, the explicatum shall be as simple as possible, that is, as much as allowed by the first three requisites, which are more important. The aim of the general theory of law is, at least partly, to introduce the definitions and conceptual distinctions needed to coherently account for the somewhat obscure ideas that jurists generally have about various notions that are central to their professional activity. For that purpose, the production of Alchurron and Boulighin is doubtlessly one of the most relevant and original contributions of the 20th century. If their pieces are judged on the ground of the guidelines proposed by Carnap, it can be said that for the most part, they broadly achieve. A crucial part of this author's work seeks to elucidate the problems involved in the analysis of legal systems. The phrase legal system is frequently used by jurists as a synonym of legal order. It is used in this way to make reference to the law of a given political community. In such contexts, legal system, legal order, and law are interchangeable concepts. For example, common use assigns the same meaning to the sentences "the Argentine legal system excludes capital punishment," "the Argentine legal order excludes capital punishment," and "Argentine law excludes capital punishment." In this vague sense, it is usually considered that legal systems are made of norms. However, a system is not a mere cluster. The idea of system or order implies some kind of link among its parts, and that relationship is what allows the recognition of diverse norms as belonging to the same system, while at the same time it provides a criterion for distinguishing one system from another, for example, the Spanish law from the Italian law. The general theory of law should accurately and clearly answer questions such as: what allows a cluster of norms to become a system? Under what circumstances can it be sustained that a norm belongs to a given system? When can it be said that a legal system has been replaced by another one? And questions of the kind. Alchurron and Boulighin, as is well known, conceive legal systems as a subspecies of normative systems. These, in turn, are a type of deductive systems. According to the definitions they provide, a deductive system is a set of statements that contains all of its deductive consequences. A normative system, in turn, is a deductive system that includes among its consequences at least one norm, that is, a statement that depicts a conduct as obligatory, prohibited, or permitted under certain given generic circumstances. In other words, norms connect generic cases with normative solutions. Lastly, legal system is defined as, I quote, the normative system that contains statements that impose sanctions, that is, among which consequences there are norms or solutions that include a coercive act, end of quote, of quotation. The suggested notion comprises some of the typical uses of the expression legal system by the jurists, and at the same time offers a very precise identity criterion. Actually, by identifying the system with a set, the extensional identity criterion of set theory applies, which is to say, alpha and beta are identical if and only if they have the same members. Furthermore, it is useful as grounds for the analysis of the formal properties of normative systems, for the precise description of the different senses in which it is usually spoken of legal gaps, for the definition of the notions of legal redundancy and contradiction, for recreating systematizing activity of legal science, and for shedding light on various problems of the general theory of law. At the same time, by making identity criteria accurate, it allows the perception of the problem that another notion of legal theory generates, that legal systems are dynamic. This is to say that they are subject to change through time, and that such changes affect their members but not their identity, which means a legal system can prevail through time without losing its identity, even when their members vary at different times. As it happens, this idea is problematic because if a legal system is a set of statements, any addition or subtraction of any of its members will cause it to be a different system. Joseph Raz calls momentary legal system that which, I quote, contains all the laws of a system valid at a certain moment, end of quotation. While by legal system he understands a set in which momentary legal systems are subclasses that can have every, some, or no law in common with the other subclasses. I quote, the phrase, the English legal system at the beginning of the reign of Elizabeth II is ambiguous. It may refer to the momentary system of that particular time or to the legal system to which this momentary system belongs. Often, such phrases are used to refer to neither, but to the system of the period, that is, to the laws valid at one moment or another during some span of time longer than a moment and shorter than the total duration of the legal system. A momentary legal system is a subclass of a legal system. For every momentary legal system, there is a legal system that contains all the laws of the momentary system. Two different momentary systems, which are subclasses of one system, may overlap or even be identical in their laws, or they may have no law in common. End of quotation. Russell's view constitutes an example of the mistake of trying to simultaneously uphold the idea that the legal system is a set of norms and that it is dynamic. This is so because the concept of inclusion is inadequate to expose the relationship between momentary legal systems and legal system, in the words of the author, as an entity that endures time, since it does not show that a momentary system includes all the norms that belong to a legal system at a given time. If a given norm n was passed at a given time t sub 1 and abrogated at a later time t sub 2, it has ceased to belong to the legal system since t sub 2. However, if the system is thought of as a set that includes all momentary systems and as subclasses, the way Russ does, then the norm n will not only go on to belong to the legal system after t sub 2, but it has also belonged before T sub 1, since the legal system is represented as a static entity to which all the norms of all the momentary systems belong. Achuron and Buligin used the term legal system with a roughly similar meaning of Russ's momentary system, though with the difference that Russ does not include all the deductive consequences of the expressly passed norms. To account for the dynamic nature of law, they introduce a different meaning for the expression legal order, which they define as a sequence of legal systems. In this way, the relationship between each momentary system and legal order is not one of inclusion, as in Russ's view, but one of membership. A domestic legal order, such as the Argentine law or French law, is not, in this author's conception, a set or system of laws, but a sequence of sets that occur over a period of time. It is necessary, however, to determine which criterion allows the recognition of different sets of norms as members of the same legal order. Jurists use several identification criteria constituted by rules of admission and exclusion, which determine what conditions need to be met by a legal statement for it to belong to a system. These criteria are usually linked to the method of creation and elimination stipulated in other legal statements that belong to former systems that are considered members of the same sequence. The criterion of admissibility that takes into account whether an act of creation is authorized by another norm of the same legal order is generally called, following Kelsen, legality criterion. Legality criterion allows to link each system with the one that precedes it in the sequence up to the earliest system. According to Alchurron and Buligin, the identity of the sequence, which they identify as legal order, I quote, is given by the identity of the criteria used for the identification of legal systems belonging to the sequence, end of quote, which is to say, by the legality criterion. We have then a static concept of legal system which roughly corresponds to what Russ calls momentary system, and the concept of legal order which intends to account for the dynamic nature of law. 2. Criticism to the notion of legal order. In my opinion, the concept of legal order proposed by Alchurron and Buligin is inadequate for the following reasons. A. It does not adequately account for the dynamic nature of law. B. It introduces a new notion of identity without explaining its meaning. And C. In order to explain the dynamic nature of law, it is unnecessary to increase the ontology with a new entity over and above legal systems. I will treat my objections in the given order. A. Since legal systems are static, given the conditions for the identity of sets, it seems adequate to introduce a different concept, such as legal order, to account for the dynamic nature of law. However, the definition of legal order as a sequence of systems, if that concept is understood according to its meaning in set theory, can't fulfill that function, because the conditions for the identity of sequences, as for any other entity in set theory, is also extensional. To be sure, a sequence can be understood as an ordered set, S sub 1, S sub 2, S sub n, or as a function which domain is a subset of natural positive numbers and which range of values is some set, in this case a set of legal systems. As is well known, the condition for identity of an ordered set is that alpha is identical with beta if and only if their first element member is the same, their second member is the same, and so on. Now, at the same time, a function is a binary type of relationship and therefore consists of a set of ordered pairs. Now, if the identity criterion is extensional, every time a new element, that is a new legal system, is added to the sequence, we are faced with a different sequence. Consequently, we meet the same problem, the solution for which the concept of legal order, as different from legal system, was introduced. To be sure, the sequence formed by the valid momentary systems between t sub 1 and t sub n, moment t sub 1 and moment t sub n, is different from the sequence formed by the systems between the moment t sub 1 and the moment t sub n plus m, if between t sub n and t sub n plus m, new laws were passed or abrogated, since in this case, the second sequence has more elements than the first, but in that case, both can't be identical to the same legal order. As I said, Alchuran and Buligin postulate that the identity of the sequences is determined by the legality criterion. To that end, they claim, I quote, only if the identification criteria change, that these are replaced by others, as happens, for example, in the case of a revolution or a declaration of independence, does the legal order lose its identity and is substituted by a new one. End of quotation. However, this suggests the use of the notion of sequence with a different meaning, which is not adequately explained. In this way, a notion that has a precise mathematic meaning is used with a different meaning to make reference to some entity whose nature is not clarified. This creates only the appearance of an explanation to the dynamic nature of law, since the explicatum does not have a clearer meaning than the concept it attempts to explain. As I will argue later, I believe that the notion of sequence with its usual mathematic meaning is adequate to explain the dynamic nature of law, and it is therefore unnecessary to give it a new meaning. B. Conceiving sequences as entities that keep their identity in spite of the addition of new members also entails the use of the notion of identity in a new sense. In effect, according to the rules for identity in first-order logic, to affirm that A is identical to B implies that everything that can be said of A can be said of B, and vice versa. This is the law of indiscernibility of identicals. It's Leibniz law. In this sense, nothing can keep its identity through change. To claim that something changes but goes on to be the same entity is contradictory, since if it has changed, there has to be at least a property that it has acquired, or one that it used to have and doesn't anymore, and therefore the same cannot be said of the entity before and after the change. As a consequence, if what is intended to explain is how law, identified with some entity, keeps its identity through changes, understanding identity with the sense it has in first-order logic, I believe we are faced with a fake problem, since we are trying to explain something that is logically impossible. And if the explanation consists of maintaining that there is something that keeps its identity in a different sense of identity, it should be explained which sense is being used. Furthermore, if the notion of identity should be defined in a sense that admitted change, the need for identifying legal order with a sequence in order to account for the dynamic nature of law is not apparent. It would suffice to affirm that there is a sense of identity in which the legal system is substituted by another when norms are added or subtracted, and another sense of identity in which it goes on to be the same. To avoid misunderstanding, the term legal system could be reserved for the system in its static nature and call it legal order when it is conceived in its dynamic nature. For instance, Peter Gich's notion of relative identity would allow to claim that A and B are not the same legal system, but they are the same legal order. C. As stated, to pose the problem of the dynamic nature of law as the need to explain what it is that keeps its its identity through time in spite of changes in the legal systems is either contradictory or it implies the use of a new notion of identity, which is obscure. In my opinion, in order to propose an adequate theoretical reconstruction of the idea that the legal order is dynamic, it is not necessary to maintain the existence of an entity that endures time as a semantic correlate for the expression legal order. As I see it, in order to explain the meaningful use of the expression legal order in the sentences in which it appears, it is enough to give contextual definitions, that is to say, to translate said sentences to sentences in which the expression does not appear. The expression can be used in the subject or of a sentence, as in, for instance, the Argentine legal order prohibits euthanasia, or in the predicate, as in the sentence statute number 23,000 belongs to the Argentine legal order, or this law belonged to the Argentine legal order between this and that dates, but presently it does not. In approximate terms, I would say that the first of my examples means something like this. There is a norm that belongs to the last system of a sequence originated by the Constitution passed by the Constitutional Congress that met in Santa Fe in 1853, in which every subsequent element is derived from the previous one by virtue of the legality criterion established directly or indirectly by said Constitution, and that norms prohibits euthanasia. My second example, statute number 23,000 belongs to the Argentine legal order, could be translated roughly as follows. Law number 23,000 belongs to the last system of the sequence originated by the Constitution passed by the Constitutional Congress that met in Santa Fe in 1853, in which every subsequent element is derived from the previous one by virtue of the legality criterion established directly or indirectly by said Constitution. The translation of other sentences may prove more complex, but it would always make reference to legal systems that belong to a sequence that links them to the earliest system through some legality criterion. In this way, for us to speak of Argentine legal order in different moments, it is enough that in each moment there is a sequence that links the subsequent systems to the original system. But it is not required to assume that it is the same sequence or to identify that sequence with the legal order. In other words, I believe that the dynamic nature of law should not be understood as the idea that, I quote, legal order can endure time without losing its identity, even when its members vary, end of quote, as Alchurron and Buligin express it. It is contradictory to claim that something changes and at the same time it continues to be the same. If the current Argentine legal system does not have any norm in common with that of 1866, as may well be the case, it is apparent that there is nothing that persists. If the problem of the dynamic nature of law is conceived as an attempt to explain what it is that persists through changes, it is a pseudo-problem, since there is no such thing. The identity criteria that we use in common language are vague and more or less arbitrary. In the case of legal order, it is based in connecting the set of currently valid norms with some set that, for some reason, is conventionally identified as the original one. As long as the subsequent systems can be considered as derived from the original system, it is considered the same order, but to assume that there is an entity that persists through changes is to make the mistake of believing that for a noun to be meaningful, it has to refer to some entity. To sum up, I believe that Alchurron and Buligin are right in their assertion that the notion of legal system understood as a set of statements with certain properties is inadequate for accounting for the dynamic nature of law, and that therefore the distinction between legal system and legal order is useful. I also believe that it is correct to appeal to sequences of legal systems in order to explain the meaning of the notion of legal order. However, I believe it unnecessary to postulate non-extensional conditions for identity for set sequences and inadequate to identify legal order with a sequence. Finally, I believe that the notion of legal order must be defined contextually without giving it a semantic correlation. Thank you very much.